Yes, Ms. Winton. Now, where have we got to on facts? Are we moving on to law, or have you got more facts you need to deal with?
Just very briefly, please, on facts, because I need to deal with Mr. Tyler's specific challenge to the learned judge's conclusions about consent. He deals with those at paragraph 54 and 55 of his skeleton.
Thank you.
And there he sets out his criticisms of findings that are then made at paragraph 134 of the judgment. Some of this has been canvassed already, but my position as an overall position on those criticisms is that those were the findings that the judge was entitled to make on the facts, having heard extensive oral evidence from the parties and their additional witnesses, and that in particular the criticism made of the judge looking at whether the appellant had an affair was relevant to the dispute that I flagged before as to when the relationship had broken down in circumstances where the appellant had accepted she had had an affair and the respondent had only found out about that in 2009. She'd had an affair at the end of 2008, and it was accepted that the appellant was then abroad from 2009 to 2011. So that puts it into a bit more of a context. And then Mr. Tyler takes issue with the judge's finding that, again, that was really accepted, that there was no consent needed for the move of the children to Dubai. And I say that that's part and parcel of the judge's overall view of the dynamics between the parties, as then fed into his overall view of the issue of consent in those circumstances. And so I say that those were all findings that were appropriate for him to make. He was certainly entitled to do so, and they were all relevant to his overall conclusion about the issue of consent. Turning then to the law, what I say is that the statute is drafted in a certain way with specific reference to the issue of consent in order to provide clarity, and that is the point that is then made in Re G in terms of the way in which the test is then enunciated by Lord Justice Mumby. In terms of the law, I would say that, first of all, the rebuttable presumption is understandable in circumstances where the court is considering the dynamics of two people who are in a marriage or a civil partnership, and therefore one can see how the presumption is that there would have been consent, but of course it can then be displaced. Secondly, I would say that proof against consent
Could I say, I made this point before, and there may be no difference. I just want to leave open the possibility that there is. It's a presumption of parentage. It's not a presumption of consent.
Yes. Yes.
But it may make no difference. But
yes. Yes.
Since we're looking at every single word of this.
Yes, of course. And I did pick up on what you had said before, but I've slipped back into talking about consent.
Thank you.
Yes. There was discussion before about how you prove that there hasn't been consent, and the point about the make weight. First of all, I would say that when you look back at Re G at paragraph 26, the easiest place to find it is in Mr. Tyler's skeleton at paragraph 36. There is a balance in what is said because Roman numeral 3 talks about countering the presumption, and then says, so even weak evidence against consent having been given must prevail. But it does then say, if there is no other evidence to counterbalance it. So it's not in my submission necessarily as simple as it, and this was not the circumstances of this case either, where you would have one piece of evidence and therefore the whole rebuttable presumption would be undermined. In my submission, it's more a case, given the way in which the court generally considers the overall dynamics of a relationship, not just in this sort of situation, but in an array of family law cases, that you're looking at the overall position on the facts when you then come to review as to whether or not the presumption is rebutted, much as I would say the judge did in this case. And the balance is there in Re G, so that if you come across a piece of evidence that would suggest the presumption can be rebutted, you would still need to look at whether there were any countervailing pieces of evidence and then form a global view under Section 42.
So what is the point of interposing weak evidence? How does that help the court?
I think the point that's being made is that once you have a piece of evidence that undermines consent, you have to, as the court, sit back and think very carefully about whether the presumption can be rebutted, and then cross-check to whether there's any countervailing evidence, and then come to an overall view. But that, in my submission, isn't necessarily a particularly difficult thing for a judge to do at first instance. It's a question of balancing factual evidence as a judge would be used to.
Why isn't it just simply, does the evidence show that she did not consent? Why do you have to look at this weak evidence and a make-weight? There's a rebuttable presumption, and as Mr. Tyler submitted, is the evidence sufficient to overcome that presumption by showing that she did not consent? I'm not sure that adding this sort of earlier stage, that you have even weak evidence.
Well,
I mean, are you seeking to support that as a necessary part of any analysis?
Well, my lord, my primary case, of course, is that Re G is fit for purpose, and that was the test that was applied by the judge.
Right.
And
so you
that
do
he got
support
it right.
each element of it?
I do, but my lord, if you say that perhaps the language is not as clear as it could be, what I don't agree with is any move away from the formal issue of consent. So if the language is, there is a rebuttable presumption of consent unless you can prove otherwise, or you can prove that there was not consent, then I don't necessarily take particular issue with that as a secondary position. What I do take issue with is Mr. Tyler's formulation that some form of acquiescence could be interposed instead of formally considering the issue of consent or lack of consent.
That wasn't his submission. But he accepted that acquiescence was not good enough. But he went on to say that in circumstances where people are living very closely together, one had to take, I think he used the word, a nuanced view of the evidence to find out whether that was or was not consent.
Well, what I say is certainly his skeleton reads as an inference of consent, which I took.
Well, inferring consent is different from inferring acquiescence, or from acquiescence. We're all used to concepts of inferring what people's position is on something from their conduct. And that I understand to be the proposition that you're meeting. But it doesn't have to be written on a form, I consent. The consent can be inferred from the evidence.
Yes.
That's not controversial, no doubt.
Yes. Well, I mean, in my submission, that's what Re G says already. It might not be as clear as the court would like, but Re G does not say that it has to be on a document. And the learned judge was very clear about that. That was certainly not the case that we ran at trial. It was looking at a broad canvas of the facts and coming to a view about whether the rebuttable presumption could be displaced with evidence to the contrary. So in my submission, Re G, or if needed, a slight reformulation, doesn't in fact change the actual test that the court would have to consider, or would necessarily therefore have an impact on the facts of this case.
Can I just explore that a bit further?
Yes.
With you, Ms. Renton? because my reading of paragraph 26 is we get to little 2.
I'm so sorry. Are you referring to Read G?
I'm in Read G,
Yes.
sorry.
Yes.
Paragraph 36 of Mr. Tyler's
Yes.
skeleton argument. So we've got 1 and 2, which I think we all think is pretty controversial. But when I get to numbers 3 and 4, it feels to me as though what Sir James was effectively doing was showing trying to say this is a very easily rebuttable presumption. Really, can't wait, weak evidence, no awareness, no acquiescence, and then what is needed is a deliberate exercise of choice, which of course it doesn't say in the Act. And it might be thought isn't wholly compatible with a presumption. Now, am I wrong about that, or what is what I must draw from Read G, which you are adopting, is it's very easy to displace the presumption of parentage?
Well, I mean, firstly, I would say that the phrase "make weight" perhaps isn't particularly ideal, but would just suggest...
Or weak evidence when you've got a presumption of parentage? To displace a presumption of that nature?
Well, that's why I drew your attention to if there's no evidence to counterbalance it, because that perhaps puts a balance as such with the phrase of weak evidence.
And what about consent requiring a deliberate exercise of choice?
Well, I would say that is a turn of phrase with an eye to the overall statutory framework and...
Which part of the statutory framework?
Well, in terms of the fact that Read G certainly was trying to emphasise the need for certainty with a focus on the issue specifically of consent as opposed to acquiescence. And so I would say deliberate exercise of choice is just one of the ways of framing the issue of consent. But I accept that there are other ways of looking at the issue of consent as well. But I don't submit that suggests that that's the only way in which you could consider the issue of consent.
It says what is needed is consent which involves a deliberate exercise of choice.
Well, I suppose...
I'm just not sure how that fits in with the presumption.
Well, I suppose it means as opposed to acquiescence or awareness, because deliberate exercise of choice is you actively deciding to do something. That's certainly how I would read it. Oh. And within that active choice, it could be an array of things from signing an actual document to saying, yes, of course, I'll take you to the clinic and I'm very excited we're going to have children, or whatever it is. But as I say, even if the court takes a view that some of the wording is perhaps not as clear as it could be, in my submission, when read with the statute, it is sufficient. But in any event, what I say is that even if there needs to be some amendment to the law and you don't accept my primary position, on the facts of this case, the judge's findings should still lead to the conclusion that Section 42 wasn't established by the appellant, given the array of findings that were made in this case. And so even if you were in the territory of inferring consent...
Sorry, you said Section 42 wasn't established by the appellant. But you mean it was the presumption?
Sorry, yes.
Displaced.
Yes.
She didn't have to establish.
Sorry, yes, that's what I meant.
Before you move on from this, could I just see what, if anything, there is between you and Mr. Tyler on the analysis of this subsection? I think that we came out, although it was approached in some slightly different ways, but with something of this sort for the question that the court might ask itself when applying this provision. Is it established on the balance of probabilities that the spouse or civil partner did not consent?
Yes, I don't take any issue with that.
You're happy with that? That there are certain other questions which you remember I discussed with Mr. Tyler, which he agreed would not be the right questions. I mean, one of those would be, is it established that the spouse or civil partner objected?
Yes.
You're agreeing that that's
Yes.
not the question?
Yes.
And are you also content that it's nothing to do with the communication of consent?
Yes.
And particularly, a person who's the putative parent does not have to show that they consented. That would be to reverse the burden of proof.
Yes.
So, on that analytical approach, there doesn't seem to be anything between you and Mr. Tyler as to what sort of question is appropriate and what sort of questions are not appropriate for the court to ask itself.
No, I don't take any issue with that. Right. I think talking about inferring consent perhaps is an unnecessary gloss on any of that, because sometimes the consent will be explicit and sometimes it will be part of the vagaries of the dynamics between the parties.
Well, sure, with respect, that must be right. So it can either be explicit or can be inferred from conduct.
Yes, I accept that. Much as if you were dealing with a Hague case and an Article 13A consent defence.
Did you have anything that you wanted to say about his submission, or at least the exchange that we had, about the degree of detail of the thing that is being consented to that is necessary? It's not a very helpful way of my putting it, but you'll know what I mean.
Yes.
Is, to exactly the form of treatment, as opposed to simply you're going to get treatment in order to hope to have a baby.
Yes.
I agree to that.
So I'd sort of canvassed it before, but maybe not clearly enough in my submissions, which is that I don't say in every case you as a principal have to know every detail, but I say your lack of knowledge of the detail might, in the right case, undermine.
Completely understand that, but what we're talking about is when looking at the actual section, it's the consent to placing something.
Yes, I accept that. Yes.
And so the detail of what the something is, as it were, is not the point.
Yes, I agree with that. But it might be a very telling factor when you descend into the detail.
Yes.
And so, my lord, I say, even if that is the reformulated test as such, then I would urge the court not to intervene with the factual findings that were made by the learned judge, and on the basis of the factual findings that were made by the learned judge, it would still lead to the same conclusion in my submission. So that is our case on ground one.
When you say the primary findings, I think what you were saying is the matter set out in paragraph 134. I know you took us to other...
Yes.
But that's where the judge says what his primary reasons are, and I'm interpreting your submission as being those are the findings on which you rely.
Yes. Yes, as well as some of the others that were important, but yes.
You took us to
Yes.
before the shortage, Janet.
Thank
Any
you.
more questions on
Well,
that
no.
topic?
No, thank you.
Thank you very much. So, Family Law Act.
Yes, so I now turn to ground two. Of course, my Lord Justice Moylan made clear in Re-T that the ratio was subject to further arguments.
Yes.
So here it comes.
And so here are your further arguments. There are four main aspects that I want to focus on, and hopefully I have distilled our case to some extent into the further written submissions that
Thank
I
you very
did
much for doing
yesterday.
that. Very, very short notice. I appreciate it.
Not at all. And so I wanted to look at those in turn with some additions in light of various points that Mr. Tyler had raised. We make 4 broad submissions. The first submission is perhaps the simplest one, which is that we would urge the court to follow the plain wording of the statute and in accordance with the High Court authorities that I'm not going to take you to and that you will of course know extremely well. I say that in or in connection with has to mean more than simply the existence of divorce proceedings at some time, and that connection has a plain and simple meaning to it, and that establishing connection as a question of fact is, I would suggest, in fact, a relatively easy task for a judge at first instance, and arguably as easy as conducting what would be potentially a forum conveniens analysis if the other route was adopted. Effectively, you would more or less always have the Section 2A jurisdiction, and you would then be having the argument at the Section 5 point in terms of whether or not there should be a stay.
So when you say connection has a plain and simple meaning,
yes,
how would you express that in a sentence or two?
Well, I would say that it is a broad factual inquiry that is not limited to a temporal connection, but might be a temporal connection, or might be some sort of substance overlap. But I'm going to come on and look at what exactly that means, because there has been a difference of view as to exactly what some form of substance overlap means.
So you're saying a broad factual inquiry that is not limited to a temporal connection, but might be a temporal connection, or some sort of substantive overlap. Substantive overlap of what?
Well, can I come on and deal with that in
Well, can you just tell me what the completion, the end of the sentence is? Some substantive overlap of?
Forgive me, of some sort of overlap between the divorce proceedings and the children proceedings, where there is some sort of substance overlap, and then I'll go on and explain a little bit more what I mean by that.
Other than they concern children of the family.
Yes, yes. But I say that with many things, it doesn't necessarily need to be spelt out more, because connection, I would say, speaks for itself and is a simple concept for a judge at first instance to grasp and consider, as they have done at first instance, I would say, with relative ease.
They seem to have disagreed about what the elements are, so I'm not sure it's quite that easy.
Well, I wouldn't say that they all disagree with each other.
I don't think, if you're seeking to submit something simple, and a number of High Court judges that disagree, I think it's not the strongest submission.
I would say it's relatively simple now. It's a bit like, for example, the dispute about habitual residence, which would have taken and took a significant number of authorities to boil down to a child-centric factual test on integration, and is now relatively straightforward in my submission in terms of the law. But I would say that certainly, in particular, the later authorities after your judgment in Lachau have the 3 High Court judges really sort of singing from the same hymn sheet in terms of coming to a view that it was ultimately a factual determination and not being wedded to it being temporal only, which of course was the view of Mrs. Justice Parker initially in the AP and TD case. and certainly in my submission, by the time you get to the judgment of Mr. Justice Poole in Re A, I say he enunciates a very well-reasoned, sensible, factual approach to the issue that takes away any gloss that perhaps was there before and makes it plain that one factor, such as a temporal link, shouldn't be favoured over another. And I say, in contrary to what my Lord said in Re T, that is not an opaque test. And actually, the bread and butter of a judge at first instance is to consider a broad factual landscape and to exercise their discretion about an array of issues, which include establishing whether or not there is a connection. And then, my Lord, what one perhaps descends into how everyone's arguments are labelled, because my argument has been labelled as being restrictive in terms of its approach to the statute. When I say my argument, I really mean the High Court judges' arguments that support what I now say. But in my submission, that is really an unfair way of labelling the approach. Because I would say that my approach is broad, but broad enough. And I would say, with respect, of course, to the judgment in Re T, that the approach there is too broad and effectively amounts to a boundless discretion that doesn't pay sufficient regard to the plain wording of the statute. And so one then has to look at the way, of course, the statute was actually drafted. And in my submission, if the intention of Parliament had been for this to be a jurisdiction in respect of proceedings for divorce and so on, which are continuing, it would have been more than possible for that to be what the statute says. But that is not what the statute says. And in my submission, there has to be a reason for that. I looked over the luncheon adjournment at the documents that were sent by Reunite, and they sent through the draft bill, which is actually annexed, because I've certainly seen it before, to the Law Commission report, but I'm not sure why it's not ended up in the authorities bundle, and what the original draft was of the statute before it was amended from February 1991. And it's right to observe that in those documents there is a reference to in or in connection with, but they don't, that phrase doesn't form the subheading of the jurisdiction, which is what was then put in by Parliament. And that is curious in my submission as to why Parliament chose to give more prominence to the phrase in or in connection with.
So you're moving away from the authorities because you were going to tell, you said you support, or you Mr. Justice Poole's analysis
Yes.
in Re A.
Yes.
Where he was really saying, I think, that if you look at paragraph 25 of his judgment,
Yes.
there has to be some factual, temporal, causal, or other connection.
Yes.
And you've said that it's not limited to temporal, but it might be. There has to be some sort of substance or substantive overlap. So I'm just trying to understand what is it that what is the substance or substantive overlap?
Yes. Well, I can deal with it now.
Are you coming to it later?
Yes. I mean, I
Okay.
can.
Well, they don't. They come
Whatever's
to
going to be of most help to the court. But yes, I mean, the issue I would say is that connection has to be delineated somehow. But what Mr. Justice Poole said is a very wide canvas for then the analysis of connection to take place on. So it might be temporal, it might be some sort of substance, or I would say causal and substance really also are sort of overlapped potentially in concept. But there's obviously got to be something that makes a connection. But in my submission, for that to be viewed as fit for purpose, doesn't involve the court having to enunciate every single possible way in which there might be a connection. Because in my
the difficulty, I mean, can I come at this from a different angle, not,
yes.
not being something that I've previously grappled with? That looking at the test identified by Mr. Justice Poole in his judgment in Re A, I've got to page 146 of the language, but anyhow, it's paragraph 20,
Yes.
sub 2. I'm just wondering how some connection, ... to the end of that sentence. Just wait till you...
I'm so sorry.
No, not at all. No,
Yes,
just wait till you have it in front of you.
Yes. Yes. Yes, I'm there, thank you.
Now, I mean, clearly there's 1 and 3 are where one might take as being at different ends of a spectrum of approach to this, and 2 is clearly somewhere in the middle. But what I'm wondering, and wonder whether you can help us with, is how somebody advising somebody in this situation could possibly operate on the basis of 2, because it's so imprecise. I mean, I think my Lord's expression was opaque, and you certainly, I mean, I know it's a tough gig appearing pro bono in the Court of Appeal trying to persuade the court to change its mind about something, but it doesn't apply, as it were, to those of us who weren't on that court.
Yes.
So, and indeed, my Lord's mind remains always open, but I just don't understand how that test runs, how anybody advising clients in this situation, or judges deciding, would know where on the compass that test lay. It seems to be, you can just look at anything or everything and decide whether there's a connection. But what does that mean? I mean, can you give us some examples of something that's going to fall one side of a line, something that doesn't fall one side of a line?
Yes, very well. So I would say, first of all, that in the family court, you have an array of issues when you're interpreting statute that are subject to an incredibly broad discretion. In the children jurisdiction...
So the answer is going to be then, fair enough, it's an incredibly broad discretion.
Yes.
Is that really where we get to?
Yes.
Is that how this ought to be operating? That people go in front of a judge and to find out whether they can come to this court or not is an incredibly broad discretion?
Well, I would say with respect that applies for other aspects of jurisdiction. And I'll give some examples. For example, determining the way in which a judge will decide habitual residence, I would say, is an incredibly difficult task to advise a client on. Sufficient degree of integration with an array of case law examples where 2 months is sufficient, 8 months isn't, 6 months is, a year isn't, in all kinds of different factual circumstances, I would say, anecdotally, is an incredibly difficult piece of jurisdiction to advise a client on. That's one example, that habitual residence is a broad factual analysis on a case-by-case basis and is the gateway of our substantive welfare jurisdiction. That may be the best example, because other elements of jurisdiction are sometimes more limited. For example, if somebody has prorogued, that's relatively clear. And so you have that broad discretionary exercise. But one could say the same as well about forum convenience. Which court is a convenient forum is broad, factual, an array of examples that go in all different directions, different factors that a judge at first instance needs to take account of, and again, difficult to advise on. None of these things are particularly straightforward in my submission.
Accepting what you say for the moment, but where it's looking at a connection which may exist, understand proximity in time. What does overlap of relevant facts mean? What is the overlap of relevant facts between a divorce proceeding and a children case mean?
Yes, so can I answer that by giving some examples? What I would say is that, first of all, as an overview, I would say that in fact the need to try and find a connection is probably relatively confined in terms of number of cases, because I would say that in most cases when people are getting divorced, they are likely around that time to also be dealing with the fallout of the relationship in relation to children. And so the cases are confined to more unusual cases where there has been some form of time lag.
So does it mean overlap of relevant facts mean that there was a custody battle at the time of the divorce?
It might mean that, yes. It might mean, so forgive me, I keep saying I'll give some examples, and I will now give the examples. It might be that, for example, you issue a children case, even in a no-fault divorce era, and say, I'm issuing the children case, I have suffered domestic abuse, it's one of the reasons for the breakdown of the relationship, here I am now with my children application, we're also getting divorced. And there would be an obvious connection. It might be that you say the connection is we got divorced and we put in place a parental agreement. Here we are 2 years later, that's fallen apart for a variety of reasons, whatever they might be. Here I am now with my children application. Again, I would say relatively easy to establish a connection.
But that's happenstance. I mean, it's pure happenstance as to whether there is some happening of that sort at the time of the divorce, or whether the problems only arise later. So why should the situation of the children be different because the parents didn't happen to go to court about them at the time of the divorce?
Well, because I say that that's what the intention is of the statute.
Yes, but I mean, I'm just testing it. So
yes.
You're accepting that in fact that means that it has a random effect, the statute, meaning that for some children whose parents didn't go near a court at the time of the divorce, they won't be caught. Whereas parents who went straight in, there'll be a connection.
Not necessarily, because it might be that you say in your children application, I was the victim of domestic abuse, we got divorced, it was a very unhappy situation, we've struggled on for a number of years, but I was always concerned about, I don't know, that there was sexual abuse, for example. These are the things I've done to safeguard, but here I am 3 years later, and now here is my children application. And therefore, in those circumstances, again...
So it doesn't cater for the situation which things are going perfectly well for a period of time, and then blow up?
Well, it would depend on how you framed it, because it might be, for example, that things had gone well and you'd had some sort of agreement in relation to the children, which is highly likely, and that you then issue the application. But it's not any less arbitrary, I would suggest, than circumstances where only people who have been married or in a civil partnership have access to this jurisdiction. So in terms of a catch-all, it's not a catch-all. Why, I would rhetorically ask, is somebody entitled to what would be an incredibly broad jurisdiction in relation to their children because they had got married or were in a civil partnership?
But that applies to financial remedies, it applies to schedule, to all sorts of different situations where marriage is treated separately from marriage and civil partnership, I should say, treated separately.
Yes.
Can I just test it right away with another couple of examples? So we know there's a big push towards mediation. So if a couple go and have private mediation, and then things fall apart subsequently, that a connection or not a connection? They've not issued proceedings, not actually ever got in front of a court where the divorce was going, but they've followed the government policy of taking private law proceedings away from the courts, and they've got mediation.
Yes, because if you're dealing with child arrangements as the fallout of the relationship.
It's not in connection with the divorce.
Well, it's in connection with the divorce because the divorce is happening
proceedings.
because of the fallout of the relationship, and so you're then dealing with the children
Right.
because of the
So
fallout
that
of the
would be a
relationship.
connection.
Yes.
But I thought my lady's question is there's a time lag. In other words, mediation at the time of the matrimonial civil partnership proceedings, a year goes by.
Yes.
Is that right?
Well, it might be on the facts.
2 years goes by. Is that right? 3 years goes by.
It might be.
Jurisdiction continues until the child is 18. So in what circumstances do you say, can you give an example of parents separating, divorcing, when the child is aged 6 months, proceedings at age 17? Is there any scope for a connection in that case?
Where they hadn't had any disagreement about the child until the child was
Well,
17.
mediation or anything, doesn't matter. Yes.
Well, I suppose
Yes.
it matters what's been going on. I suppose if they got divorced when the child was 1 and everybody was happy and there was happy co-parenting for 16 years and somebody issued an application,
You would
I
say
would
no.
say
So you
no.
have to link the issue somehow back to, well, actually, this has been bubbling along for 12 years. I was always concerned about this, and so I can relate it back.
Yes.
Is that it?
Yes.
And what are you
to some
relating it
extent.
back to?
Well, the statute says in or in connection with the divorce proceedings or the civil partnership proceedings.
Yes.
And I would say that as a matter of logic, that means that it's linked to the fallout of the relationship.
What, the
or anything
irretrievable breakdown?
yes, and anything that ensues around that.
Right.
Otherwise you wouldn't be getting divorced in the first place.
So if you are being a purist, if there has been a breakdown in the relationship, an irretrievable in year 1, and they're no longer living together, and as Mr. Justice Poole said in his option 3, there are issues of child arrangements. Why do they arise? They arise because they're no longer living together. They arise because their relationship is irretrievably broken down. Will there not always be a connection between the need to seek the court's assistance in making a child arrangements order to the fact that they are no longer living together as a family?
Well, there might not be. But
How
you would
could
have
there not
to,
be?
But you would have to assess it on a case by case basis.
Well, what would make it within or without? In other words, what is it that requires them to go to court? It's that they're no longer in the relationship that they were in before the divorce or civil partnership proceeding.
No, I wouldn't accept that because that would then just lead to once upon a time we were divorced and therefore we can issue
Well, that would
an
lead to
application.
Mr. Justice Poole's third option.
Yes, but I don't.
And what's
I
wrong
don't-
with that?
Well, I
What's
don't
wrong with
endorse
that?
his third option.
What's wrong with that
Well,
as an outcome?
Well, his third option is what my lord has said in Re-T.
I know. It's another way of asking the same question. But
Which I still don't agree with.
as we were looking at paragraph 20,
Yes.
your answer, I think, is that's too broad.
Yes, of course.
Right.
Of course.
And that's why I was testing it.
Yes.
What is it that you're saying that there has to be a connection, there has to be some dispute between them, some evidential concern that still is sort of limping on in some way 1 year, 2 years, 3 years, 4 years, 5 years later. And so I'm saying even applying your argument, why is it not the fact that there have been divorce proceedings, which is itself a connection?
Because I say that that's insufficient for the purposes of establishing a connection.
And
that there's
why
got
is
to
it
be more.
insufficient?
Because I say that connection doesn't just mean the existence of the divorce proceedings. I say that it has to be some sort of overlap in terms of subject matter, facts, or substance, or temporal proximity. Because that is, I would say, the true meaning of in or in connection with. Because otherwise the statute would just have said continuing. a jurisdiction in relation to divorce proceedings that are continuing. And it just means that it's just so broad that it relegates the phrase in or in connection with to being, I would say, completely OTOs.
What is the connection of subject matter, as an example?
So the connection of subject
what would be
matter
and what
could be,
wouldn't be a connection of subject matter?
so the connection of subject matter could be, for example, domestic abuse. I'm divorcing you because you have been abusive to me. I'm issuing the children proceedings because I need to regularise the position for the children in light of that asserted risk. That could be the substance.
Well, so it's something specific to. You find that the issue of domestic abuse, as it were, gives rise to anxiety about the welfare of the children, and that therefore the proceedings about the children are connected.
Yes, I mean, it's just one example. It could be, I'm from Spain, you're from England, I would like to go home and live in Spain, you didn't want that, I decided that therefore the marriage had come to an end, and therefore I issued a divorce petition, and then I issued children relocation proceedings. That could be another example of connection. But it's connected. In the example of what you asked me in terms of subject matter overlap, those are some examples where the subject matter would be overlapped. What I don't accept is that I need to have said on the divorce petition X, Y, and Z in order for there then to be substance overlap, because of course in an era of no-fault divorce that is going to be unworkable. But of course I can put in my C100, these are the reasons why we decided to get divorced, and this is why I've now issued the application, and that would give me the connection in my submission. Because
So are you going as far as saying that there has to have been some difficulties in relation to the children at the time of the divorce, which provides your overlap?
I wouldn't say
before the section can bite.
I wouldn't say that absolutely has to be as a rule, because the court should really stay clear of sub-rules in a very broad factual discretionary jurisdiction. But I would say it's highly likely that that is what would cause a connection, or there would be some sort of temporal link. But what I would suggest the judges at first instance have been trying to stop is a completely boundless discretion and jurisdiction, whereby just the existence of the divorce proceedings, even if they were 16 years ago, allows you to have a substantive welfare jurisdiction in England in circumstances where we now have a fairly contained international framework over that. And I will say that that is not what the intention was of the Family Law Act in the first place.
It's a, as I understand it, it's a. You can under that arrangement you can apply to be let in, but on consideration the court can say no, we're not going to deal with this.
Yes, and I understand that.
So it isn't sort of boundless.
Well, it's boundless
if there are
at the first
cases
stage.
that the court considers should not be there, it can deal with them appropriately.
It's boundless at the first stage. I accept there is then what I would call the safety valve of the section 5. But what I would say to that is that that's not a simple exercise. That then involves litigants entering into a forum conveniens analysis, potentially at great length, with an uncertain outcome.
Just remind us, where's a convenient place to find Section 5?
I think, embarrassingly, in the absolutely huge authorities bundle,
Yes.
you haven't actually put in the statutes.
Thank you. Sorry, I left mine downstairs. So, seems, I mean, I just, thank you, suggest to you that Section 5 looks as if it sits cheek by jowl with the other provision, providing a situation that prevents this sort of free-for-all that you're anxious to avoid.
Yes.
Whereas the other way of looking at it seems to provide, speaking for myself, an entirely random effect of the in connection with test, whereby people never even get the chance to make their case.
What I would say is, first of all, Section 5 isn't limited to this. So Section 5 is the general power to say in relation to any jurisdiction
Right.
under Part 1 orders. So it's not as though, for example, a statute was drafted specifically in mind that there would be a boundless, I would say, discretion under Section 2A, but it would then be specifically bolstered, forgive me, mitigated by Section 5, just to make that point. The second point is that I would say, as a principle, the court has to very carefully consider when this court should be permitting a substantive welfare jurisdiction as a starting point, and that the answer of, well, you can have an argument about forum conveniens at the stage of Section 5 is not necessarily any particular comfort for any litigant, because they are arguably in just as an uncertain territory as they would be in with the connection test.
Take the facts of this case, for example. Let's suppose the right outcome was that the courts in this jurisdiction do have jurisdiction to the power to make Children Act orders. There's nothing that would prevent your client from coming forward and saying, but you should decline to do so because ABC. I mean, in this particular case, you run into the very difficult fact that there's no alternative forum
Yes.
to decide it, which might be said to support the broader reading of in connection with. But leave that aside for a moment. That if you were living in country X, which had a perfectly good setup for deciding the arrangements for these children, and you were simply saying, they live here, they've been here for years, what are you doing in England? It would seem like an obvious case in those circumstances for the court to say, well, Section 5, no thank you, go and do it in country X. So
Yes.
what's wrong with that as a model?
Well, I suppose the point is that if we're looking at how we frame the law, we're not just doing it for the obvious cases, we're doing it for all cases, because equally I would say that it will be obvious in most cases what a connection is, and therefore there's not a great deal of difficulty in somebody establishing
Well, I
that.
gave you two examples, one of which was our case, which has a particular
Yes,
fact in it,
yes,
and the other is a very workaday case in which there just happens to be another jurisdiction that might be better placed.
yes, and one may be a much shorter forum conveniens hearing than another, but that doesn't mean that in some cases there won't be a fairly complicated, lengthy process in terms of having forum conveniens analysis. But as I would say, as a principle, the court has to consider whether to allow the gateway jurisdiction to be open, irrespective of any secondary safety valve that could be put in place, and that is not what the statute was intended for, and that any suggestion that it would sort of truncate litigation, I would say, might be unfounded, because a forum conveniens argument might be longer than an argument about what connection means in some cases.
Well, on a different subject, this hearing, as you told us, took 4 days,
Yes,
and I appreciate there were two or three big issues for the court to decide, but would it be right to form the impression that really these sorts of hearings shouldn't be lasting for 4 days?
absolutely not. I would say, and I've said in my additional submissions, that if it was just an argument about whether Section 2A applied, it would be a day, maybe 2 days as an absolute maximum. It would be similar to having an argument about habitual residence if you could do it on the basis of submissions, and that the 4 days was because of the need for there to be oral evidence about parentage. And an array of additional witnesses were allowed in, and the evidence increased after that point was raised. So it would be short-circuited in my submission, but it probably wouldn't be any shorter in length, arguably, than most forum convenience disputes.
Thank you.
Thank you.
So that's how you would interpret in connection with,
Yes,
and that's how you would limit it.
yes,
So broad, but not that broad.
yes, indeed.
Now, we're,
So before I come on to dealing with the Law Commission report in a
Yes.
bit more detail, I just wanted to deal with the documents that were sent in by Reunite.
of course, thank you.
There are two documents. One, as I said, is the draft bill that is attached to the Law Commission report, but I'm not sure why it didn't make its way into the authorities bundle. And then one is the original enactment of the Family Law Act before it was changed to the current statute that is now the subject of the appeal in February 1991. And so what I wanted to say about that was that first of all, if you look please at the draft bill and then turn to paragraph 7, please.
Sorry, was this something sent in over the break today?
Yes.
When you say paragraph 7, you mean paragraph 7 of the notes?
Yes.
Yeah.
Yes. I'm sorry.
Sorry.
Yes. So under subsection 5.
If it's called extracted pages of the document that we give, yes.
Yes.
Thank you.
Yes. So at page 7, I just wanted to flag that is where in connection is referred to by the Law Commission when considering the draft bill. And that the way that the draft bill is framed, when you look back then to the beginning of the document, the draft bill that was proposed is not the statute, is not framed, forgive me, in the way that the statute is now framed. So the specific subheading, in or in connection with, under section 2A, is not what was proposed by the Law Commission.
Sorry, I'm not following.
So,
You've taken us to subsection 5.
yes, so subsection 5 is the notes.
7, yeah, but it's you took us to the notes in respect to subsection
Yes,
5.
yes, sorry, I should have done it the other way round.
The subsection 5 has the phrase in or in connection with.
Yes, it does, but it doesn't have it. The way that it's done is as part of that clause of the statute, as opposed to being what is now the subheading of the jurisdictional section. In other words, it's not exactly the same as section 2A is, because section 2A has a big heading saying jurisdiction in or in connection with. So I'm just observing it's not exactly the same. And then when you look at the other document, this was the original draft of the statute, which is probably more helpful to look at. The way that it was framed, this is subsection 4, which is now subsection 2A. Again, it's entitled Jurisdiction in Divorce Proceedings, and the reference to in or in connection with is then subsection 5. And then the statute was reframed in February 1991 to the current framing of the statute. So my only point is this, which is that it has changed. It's unclear why Parliament specifically changed it in the way that it has, because arguably in my submission from February 1991, the subsection for jurisdiction specifically flags at the start now in or in connection with, and has been given more prominence. And I don't think, to be fair, any of us at the bench have an explanation as to why there has been that change. Certainly having looked through Hansard nothing has come up at all in any event in terms of parliamentary intention for the statute.
So it's just been filed somewhere else in the legislation. It's just been filed somewhere else in the legislation, the provision, is that?
Well, I would say it's been given more prominence in or in connection with since February 1991.
Well, what difference can that make?
Is.
It's always the same words.
Well, I think you said it's elevating its importance.
Yes.
By underlining it
Yes.
within a heading.
Yes.
Okay, that's it.
I mean, arguably, is my point. I mean, as I say, I don't know. I don't think anyone knows exactly why it was reframed in that way, but it is a change. So, moving on then to the Law Commission report.
Yes.
And to the overall intention of the Family Law Act. What I would say is as follows, which is that the Family Law Act, of course, is current law. It has, of course, been amended to take account of our obligations under Brussels 2A and then the 96 Hague Convention. But it cannot be ignored in my submission what the original intention was of this statute. And so when you look at what the original intention was of the statute and what I will say the focus was of the Law Commission report, and then consider how this now, I would say, archaic statute should be interwoven into our law, taking account of our international obligations under the 96 Hague and the other jurisdictional schemes that we have to now apply as well. I would say all of that leads the court to a conclusion that there should be an approach, as I have suggested, and a more refined and less broad jurisdiction than what the court determined in RE-T. So, going back for a minute, what I would say is as follows, which is that the Law Commission report is, of course, a secondary external aid to statutory interpretation. And the court's starting point is, in my submission, the plain wording of the statute, and that certainly the Law Commission report should have less weight placed on it than that plain wording. We then turn to Pepper and Hart, and I'd invite you please to just have a look at Pepper and Hart. It's in the authorities bundle at 677, and then within that report, the speech of Lord Brown-Wilkinson at 630 to 631.
677.
So for ease, I hope, it should be electronic page 710.
Could you take us the internal page in the report so that we...
Yes, so the internal page in the report is 34.
Thank you.
So second paragraph down, Lord Brown-Wilkinson in Pepper and Hart refers back to the ex parte factite House of Lords case from 1990, and that is the case that led to the acceptance that a court could use a Law Commission report as an external secondary aid to statutory interpretation to ascertain the mischief which the statute was intended to cure, but not for the purpose of ascertaining the meaning of the words used by Parliament to effect such cure. So it had quite a limited focus to it, much as using Hansard, according to Pepper and Hart, has a limited focus. The wording has got to be ambiguous or lead to obscure results before you can use a Hansard report.
Sorry, can you make that submission again? I'm not sure I quite follow it. Based on this, you're saying that the purposes for which the court can look at a Law Commission report is limited to ascertaining the mischief. Is that it?
That's right.
But what this actually says is, in fact, and I think there are other later decisions, including from the Supreme Court, that support for wider use, went further than this and had regard to a Law Commission report not only for the purpose of ascertaining the mischief, but also for the purpose of drawing an inference as to Parliament's intention from, etc. So, I don't...
Sorry, yes. Forgive me, that is my error. But
And if you look at more recent decisions from the House of Lords, yes, they say it's secondary, but you can look at it for context. In other words, it's part of the context of the legislation. The Law Commission reports are part of the context. I think Lord Hodge said that in a case called Rio, I think it was, and other cases. So I mean, it's not a... and I think the reports are littered with reports looking at Law Commission reports for the purposes of helping the court understand the meaning of the statute.
well, yes, and forgive me, I certainly didn't mean to mislead the court. I had just, in fact, only read the first part as I was making my submission. But yes, I accept that it's also for inferring what Parliament intended.
Well, and now the expression is context, isn't it? You're looking at the context of the legislation, and the context will include any commissions, not necessarily Law Commission, there might be other committees or commissions,
Yes.
but including the Law Commission to understand the context.
Yes, so I'm not suggesting, to be clear, that it's wrong to make any reference to the Law Commission report. I just
Right.
wanted to set the Law Commission report into a context.
Would you say that RET went beyond the permissible context?
No, I don't say that, but I say that that RET was wrong to place too much weight on the Law Commission report, given what in fact the focus was of that report, and that really is my prime submission. And so what I mean by that is that in my submission, it's very clear from the Law Commission report that the purpose of the Family Law Act 1986 was intra-UK disputes. And I'm going to give a number of references, and I'm going to also deal with the contrary assertion that it also envisaged international cases, because I say, although it did, it was far more narrowly confined than is perhaps being asserted or accepted by the court in RET, and that it certainly didn't cater or even contemplate the sort of situation that this court is contemplating. And so if I can start with just looking, please, at the Law Commission report. So first of all, paragraph 1.1. So this is Authorities Bundle, electronic page 777. This is what the Law Commission was commissioned to review.
Sorry, a minute.
767.
Thank you.
Sorry. So paragraph 1.1 is number 1, jurisdiction of courts in British Isles. Number 2, recognition and enforcement in other parts of British Isles. So those are intra-UK. And then paragraph 3, recognition and enforcement of custody and similar orders made outside British Isles. And then a similar point made in terms of administrative problems regarding enforcement within the British Isles or elsewhere. And so this is just the beginning reference, but to the extent that the Law Commission were considering international cases, they were considering it in the context of recognition and enforcement of custody orders outside of the UK. What they weren't considering was an entire jurisdictional scheme that could be applied to international cases, cases like this or other cases.
What does sub 1 mean?
basically the jurisdiction of the courts in the British Isles.
Yes, the court.
So that's
the base-
intra-UK.
Yes, the basis of the jurisdiction of our courts to make orders for custody.
Yes, but
But why is that not what we're about here?
because this is the first reference I'm going to give, but my point is that the overall tenure of the Law Commission report was about ensuring that there was no issue as between a court in England, a court in Scotland, a court in Scotland versus a court in Northern Ireland, and so on, and that there was not going to be a contest or an issue where two courts within the United Kingdom
Right.
were not all synced up as such, and that there was then going to be a conflict of jurisdiction. And that, in my submission, is clear from the overall read of the Law Commission report.
But was it not addressing, I mean, to adopt your expression, looking at an entire jurisdictional code? It was creating an entire jurisdictional code.
For the United, I'm going to say United Kingdom as a shorthand. For the United Kingdom, I would say.
But it's the entire that I'm emphasising. Yes, it was looking at intra-UK, but it was for the purposes of establishing an entire jurisdictional code. And it's either entire or it isn't entire. It can't be partially entire. And you said it was an entire code. There aren't any other bits, are there, that we've missed?
No.
Right.
It was an entire code for the purpose of ensuring there were no conflicting jurisdictions within the UK. And the international element was considering how any order for custody made by a court within the UK would be recognised and enforced outwards, and potentially the other way round, but really outwards. And that was the scope of it. So, for example, my lords and my lady will know, when you read other aids to interpretation for conventions and so on, if you've read the Lagarde report or other examples, they will specifically refer to examples between signatory states, how it then interplays with a non-signatory state and so on, and all of that is then contemplated when you then look at the convention and the jurisdictional scheme. None of that in my submission is contemplated by the Law Commission at all. Not just because, to make the obvious point that none of these international instruments or regulations were in play at the time, because of course they weren't, but they didn't go any further than that in their thinking, save for thinking about the enforcement of orders. And that is important in my submission, because what it means is that when we're looking at the law now, which I accept, of course, is the law and has to be applied, to look back at a Law Commission report that wasn't focused on how the law would be interpreted and applied to this sort of situation is, in my submission, problematic. I'll give a few other examples, if I may. So, one is 1.16 of the report. There is a passing reference to the 1980 International Conventions and how the resolution of conflicts of jurisdiction outside of the UK and the international aspects of the problem were being kept in mind. Some of these references I'm giving you in order that you have the full picture as such.
But if you look at the end of 116, although this report is not...
116.
116. You took us to 116?
Yes.
Although this report is not concerned with the resolution of conflicts of jurisdiction affecting countries outside the UK, in formulating our proposals for reform, we have kept the international aspects of the problem in mind.
Yes, I accept that. So I'm trying to give you references that are both ways.
Yes.
But I'm still going to make my overall point.
Right.
And then what I say is that when you then look on, first of all, crucially to the actual recommendations for the Section 2A jurisdiction, that's section paragraph 4.6 onwards, that is all specifically referable to intra-UK disputes. There's no mention at all of what are we going to do if we're dealing with Spain or America and how is that going to work out. So having sort of kept it in mind as such, the specific recommendations for this specific ground of jurisdiction are only referable to intra-UK.
When you say intra-UK, it's setting out the basis of on which courts can exercise jurisdiction in each part of the UK.
I accept that, but with...
So it is a jurisdictional code.
I accept that, but the purpose of the jurisdictional code was to ensure that there was consistency of approach on an intra-UK basis. And that therefore a court in Scotland didn't make a custody order and then a court in England did as well, and you had the conflicting jurisdiction. And that is the rationale in my submission for Section 2A. And that is clear from the report, I would say. And then, I'm sorry to jump around a bit, but if you go back then please to 1.12 and 1.13, these are some references to an international dimension. An example given of married couple, so 1.12 is the example. Married couple, domiciled in Scotland, move to a Gulf state, have an argument, child comes to England, mother makes a High Court custody application. And then the Law Commission analysed the way in which the jurisdictional schemes would be dealt with. But again, on the basis of would it be the court in Scotland or would it be the court in England? So that's the sort of international example. And then 1.13 is really about the recognition and enforcement of custody orders. But nothing more, I would say. And then a few other references. 4.34. Talks about halfway down the paragraph, new jurisdictional rules which we're proposing are designed to have effect on an international basis in the sense we have indicated. I say that's very important because actually when you go back and look at the other paragraphs I've referred to, in the sense that we have indicated refers to the recognition and enforcement of custody orders.
Sorry, say that again.
So paragraph 4.34
yes.
talks about, they say, 5 lines down, the new jurisdictional rules which are proposing are designed to have effect on an international basis in the sense we have indicated. And my point is that when you read back, the sense that they have indicated and the reference to the international cases is what I've already taken you to. Which
So
is
you say
all
the
about,
sense is 1.12 and 1.13,
Yes.
Is that right?
Exactly. Yes.
Doesn't it read back to 4.32 on the previous page?
Well, that wasn't my reading of it.
Well, it seems more likely that they're referring to something they've just said. Does it not?
Potentially. But that's all about, that still doesn't deal with the applicability of the jurisdictional scheme on an international basis.
The 4.32 in the middle of the paragraph.
Where do we find, have you got to hand the four bases that they've proposed, that they refer to in 4.34, Ms. Renton?
I think that's the
Right
habitual
back.
residence presence in connection with. I'm sure what the fourth one would be. I think that's the general framing of the statute as it now is, and the emergency jurisdiction. I'm grateful. Yes. But 4.32, even at its highest, isn't the Law Commission giving recommendations as to how the statute that they talk about for the rest of the report being about ensuring no conflicting jurisdiction between UK courts, with some reference to recognition and enforcement in an international context, how it would be applied in a wider international
Sorry, say that again.
framework.
It's not dealing with what?
So the focus of the Law Commission report, as I've said, is dealing with ensuring that there's no conflict of jurisdiction between different courts within the United Kingdom or the British Isles. And there is some reference to international cases,
Yes.
but their focus then is on how you would recognise and enforce custody orders in those international cases.
What do you then say about subparagraph 5 that you took us to before, the proposed section 4, that deals with stay, or appropriate for matters relating to the custody charge to be determined outside England and Wales?
Yes, well that's because, i.e. go to Scotland or go to Northern Ireland.
Goes to France, goes to Spain.
Well, but that's not, in my submission, what the focus was of the Family Law Act 1986, because that's not what the Law Commission are focused on. They clearly were trying to devise a scheme, in my submission, to put in place a statute to avoid a conflict of jurisdiction between courts in the United Kingdom, with some mention of how you would then recognise and enforce orders in the international context.
You took us to note 7, which says also extends to determination in another country.
I'm so
I think-
sorry, note 7.
You took us
there.
before. I think, so what you're saying is that they completely omitted to consider the consequences of the establishment of a jurisdictional code in the event that after a divorce the a parent moved to live in France rather than Scotland.
Yes.
Completely omitted it.
Yes, absolutely. I mean, more
Okay.
wider than that, I would say that the entire scheme of the Family Law Act 1986 was designed for intra-UK disputes.
And was not intended to apply if a parent moved to France.
Yes, well, it certainly wasn't intending to then deal with, yes, all the different jurisdictional ramifications in a case that wasn't confined to an intra-UK dispute. Yes. And in my submission, nowhere in the Law Commission report do they make any recommendations for how that jurisdictional scheme would operate in cases that we now have, like this case. And so even if you weren't to accept everything I have said and to say, well, it was a jurisdictional scheme that would at least have contemplated international cases, although, as I've said, the references really refer to recognition and enforcement of custody orders, nowhere does it actually explain how, in practice, the law would then operate going forward.
Sorry, I don't understand
with
that,
these
because it
sorts of
sets out
cases.
the jurisdictional framework that either applies or doesn't apply.
Well, it sets out the jurisdictional framework in my submission on the basis that they were dealing with ensuring that there was no conflict of jurisdiction as between England or as between Scotland. And in my submission, what has happened is that when we then entered into Brussels 2A, and then we entered into the 96 Hague, all that happened was we grafted that jurisdiction on top of this statute, leading to the amendments to section 2(1)A and B, which are, as far as I can see, basically the same. And then leading to a raft of law as to how we then applied the Family Law Act in the sort of situations that we now have. But in my submission, none of this was contemplated by the Law Commission.
So the way the argument works, I understand it, is that fair enough, the Family Law Act, whatever it was intended to do, is now applied internationally and not just intra-UK.
I accept that, yes.
Right? And that's a long-standing situation. But
Yep.
all of this submission is designed to counteract any influence, which you say there shouldn't be any influence anyhow, of what was in draft bills and in Law Commission reports.
Not quite. What my point is that the weight that should be put on a Law Commission report that was focused on a completely different scenario to this, when then interpreting the statute now, with an eye also, as I will say,
Right.
to...
So it goes that it was Family Law Act was meant to be UK only. Anything that was said at the time is only of interest but in that context.
Yes.
And therefore, when it turns out the Family Law Act has a far wider effect than that, we can forget what was said in the early stages. Is that what this submission
I
comes
would
to?
say that the weight that is placed on it should be low, as opposed to the weight that is placed on it by the court in Re-T, which is high. And that you then, instead of looking at that Law Commission report, have to look, I would say, A, at the plain wording of the statute, and B, how it interplays with the 1996 Hague Convention, and that should lead you, in particular, to a purposive construction that is more on all fours with what I say than what the court says in Re-T. So that then really brings me to the 96 Hague.
Mm-hmm.
So what I say to start with is that my argument and the suggestion that there may be some tension between this statute and our obligations historically under Brussels 2 revised, but now I would say under the 96 Hague, stems initially from some helpful commentary from Lowe and Nichols in their book, and it might just be helpful to look at that, please, just to centre ourselves on the evolution of everything. So that should be at 653 of the authorities bundle. Lowe and Everall and Nichols in the sort of colloquially called sort of Bible of international family law. Referred to a potential conflict in the context of the Brussels 2 regulation. That's at 6.21. And was something that was debated by Mr. Justice Parker in the first of the 5 cases on Section 2A, the AP and TD case. And effectively, there was a concern that there would be a conflict between having a children jurisdiction linked to divorce proceedings that was temporally linked, because those proceedings would come to an end with a final order, and a Section 2A jurisdiction that might be open-ended. And so that commentary in my submission is really sort of the starting point for considering the issue. What Lowe and Nichols and Everall then say is that effectively this isn't an issue anymore, because under Brussels 2 revised, you could prorogue a children jurisdiction that wasn't temporally limited in time, and therefore there wasn't really any issue anymore, because you could have an ongoing children jurisdiction under Section 2A, and you could have an ongoing children jurisdiction under Article 12 of Brussels II revised. And I've said in my skeleton query how that then worked with the CJU decision of E&B, which made clear that a prorogation was broken with a final order, and therefore perhaps putting back in place some form of temporal link. But that's just background, because now, of course, we are in the realm of the 96 Hague Convention. And the 1996 Hague Convention, as my lords and my lady will know, doesn't have a freestanding children prorogation, and just has a children jurisdiction as temporally linked again under Article 10 of the 96 Hague to divorce proceedings. And so in my submission, and I'm going to give some examples, there might now be a tension between what I would say is our starting point when we do think about Part 1 orders, the 96 Hague, because of course we go to the 96 Hague first under the Family Law Act for Part 1 orders. There might be a tension between our obligations under the 96 Hague and Article 10 and this court's decision in Re T and the very broad acceptance of jurisdiction under Section 2A. And so the example that I gave is in my further submissions at paragraph 10, but needs some finessing that I will explain, potentially. So the example I gave was Spain and England. Child habitually resident in Spain, divorce proceedings in England that become final. Either someone has issued a children case around the time of those or before they become final, it doesn't really matter, and then, or someone hasn't. And then I asked the question, could you then apply Section 2A? So in my submission, it depends on a number of things. First of all, it depends, I would say, on what was being discussed this morning in terms of what applies means. So if we go back to Section 2 of the Family Law Act, the Family Law Act will only apply if neither the Council regulation, which obviously is now more or less redundant, or the Hague Convention applies. And so, first of all, you would have to consider what applies means. So, there are two possible outcomes with this example, depending on what you say applies means. If applies means applies in the context of, is there a jurisdiction for this court, then in my example, under the 96 Hague, forgive me, then in my example, the answer would be no. And that would mean that you could potentially have second bite of the cherry and a Section 2A jurisdiction, having just had a jurisdiction under Article 10 of the 96 Hague. If the answer is that's incorrect and applies means applies between the two countries, i.e. between England and Spain in my example, then in those circumstances there wouldn't be the same tension, because the Spanish court would just have jurisdiction. But what would then happen in my submission if you had been in the circumstances of my example and you would have had the divorce proceedings under Article 10, they would have become final, and in my case, for example, the parents said, we want to relocate the child to America. In those circumstances, would you still then be able to have a Section 2A jurisdiction? At face value, you would, and in my submission, it would then cut against Article 10 again. So, in effect, in either example, and I'm sorry for sort of explaining it in a fairly convoluted way. But in either example, you would potentially have a parent who would be able to have exercised an Article 10, 96 Hague Convention jurisdiction within the confines of the International Convention that we have signed up to, that being our first port of call under the Family Law Act, and then have a second bite of the cherry in terms of exercising a jurisdiction under Section 2A.
Isn't that a Section 5 case?
Well, my lord, I anticipate...
As soon as somebody turns up and tries to do that.
I anticipated that would be what the court might say. But, as I said earlier, Section 5 doesn't stop the need for the court to think about whether, in the first place, there should be this jurisdiction and the confines of it, taking into account, I would say, upper pursive construction and looking at Article 10 of the 96 Hague. Given that, I would say, as I've already said, this jurisdiction wasn't intended for these sort of disputes in the first place. And so you would, on my case, end up in a very odd situation where you would potentially have the ability to issue proceedings twice, although you would be confined by the 96 Hague initially, in circumstances where you might not be able to do that if you didn't adopt as broad a definition of Section 2A.
I don't quite follow that last part, because you said all there needs to be is a factual connection. And the factual connection could be, well, inevitably, could be beyond the conclusion of the proceedings. So there wouldn't be Article 10 jurisdiction anyway.
What I say, though, is that if you're looking at your obligations under Article 10 that are based on temporal proximity, and probably also some sort of substance overlap, but at the least on temporal proximity, and you therefore have a children jurisdiction based on divorce proceedings that is confined in that way, it should mean in my submission that when you think about the correct construction of the statute, it's more on all fours with that, even if it's not exactly the same.
But you're still, on your analysis, running across Article 10.
You might be running across Article 10, yes, but it... Just
less often.
Yes, and in my submission in a way that is more confined and at least more on all fours with the 96
so
Hague.
We're trying better, still not actually achieving it.
Well, yes, because I say quite squarely the problem is grafting the International Convention onto the archaic statute is hugely problematic in my submission as a starting point. But that, I know, is an argument my lord has heard many times. But at least in my submission, when you're thinking about the way in which you would construct the statute, this pays more respect to our international obligations under the 96 Hague and fits therefore better with the scheme than the decision in RET does. So that is how I frame the case in relation to the 96 Hague. That is our position on the law in terms of Section 2A, unless I can further assist on those points.
That's very clear, thank you.
Thank you. In terms of the factual assessment, I don't think, unless it's going to assist, that it's going to necessarily help the court for me to go through that in any detail. But Mr. Tyler does plead an alternative ground in the event that his case on the law isn't accepted by the court, and I deal with the learned judge's factual determination of connection at paragraph 42 and 43, which I say was unassailable.
What paragraph?
So paragraph 42 and 43.
Oh, I have it. The respondent's alternative ground.
Yes.
Thank you.
And then, my lords and my lady, there is ground 3, of course, which Mr. Tyler hasn't canvassed orally. I don't know whether you want to hear from me on ground 3 separately.
I don't think so. I mean, if there's anything you want to add or highlight, please do.
No.
But I don't think otherwise. We've got your written
Thank you.
material on that.
Thank you. May I just turn my back for a minute?
Of course you will.
Thank you. Unless I can further assist.
No.
That's the respondent's.
Thank you very much indeed. Yes, Mr. Crouch.
Lady, my lords, firstly, Reunite wishes to extend its thanks to the court for permitting it to intervene in this appeal.
Not at all. We're always grateful for Reunite's assistance in these very difficult cases.
We have set out in the skeleton argument, firstly, Reunite's interests, and then secondly, the headline points that Reunite wishes to advance.
Yes.
Insofar as its main concern about the difficulty that has arisen in relation to the interpretation and application of what has sometimes been described as the matrimonial jurisdiction, it really is a similar or possibly the same point, but viewed from another lens, as that raised by my Lord Justice Peter Jackson, about how, as a lawyer, one is supposed to advise in cases like this, where the test can be so difficult, even, in fact, to pin down. Of course, Reunite, as two of its functions, runs a mediation scheme and a parental advice line, and parents in that context, faced with a cross-border situation concerning their child, often want to know where or whether they have a forum and how they can access that forum to resolve a dispute. And in this particular context, it's very difficult, I would suggest, for lawyers to know whether in our submission, the High Court interpretation of the matrimonial jurisdiction, there is a forum that can be accessed, because it is difficult to understand in terms of what facts meet the necessary degree of connection. And therefore, how can parents in extraordinarily high emotional situations be expected to understand whether they can come to the English court to seek relief, and if so, what relief they can expect to seek under that particular section. In relation to that then, to move into some submissions as to the law and interpretation of the matrimonial jurisdiction, I wanted to start, if it's convenient to the court, in relation to whether it was ever intended to apply, or whether the Family Law Act 1986 itself was ever intended to apply internationally. And, my lady, my lords, in my submission, in our submission, it plainly was, and that can be seen very clearly from the explanatory report, and we've set out the references that we rely on in that particular regard within our skeleton argument. There's a slight difficulty turning up the particular paragraph. At paragraph 16, and the references to the report therein, the convenient starting point, bearing in mind the reliance that was placed on it by Miss Renton within the explanatory report at electronic page 784, and the pagination I have is 781, it's paragraphs 1.12 and 1.13 of that report.
Thank you.
From which, in our submission, it can be seen that at an earlier stage of the process, and this is 1.12, a proposition was made, a proposal was made for a statute that was limited to United Kingdom cases, and that can be seen from the fifth line down at 1.12, which is, it is apparent, received some pushback. And led, so says 1.13, following that criticism, to discussions and agreement about a scheme of uniform jurisdictional rules for the making of custody orders whose application would not be confined to United Kingdom cases. Moving on within the report to paginated page 828, paragraph 3.10.
Sorry, can you say that again?
3.10.
Thank you.
Which pagination is 828, electronic page 831. Where the Commission sets out the objectives that it followed in, as it describes, framing jurisdictional rules, subparagraph 1. The rules should be uniform throughout the United Kingdom and should be of general application and not confined the United Kingdom cases, which may be said to support my Lord Justice Moylan's point that what was established here was a general jurisdictional scheme that sets jurisdiction for the courts of the United Kingdom. Where the people that were seeking to make use of that jurisdiction actually physically were is not relevant to that, save if the jurisdiction is based on, for example, the habitual residence of a child. And one can see that from a specific example that is given at paragraph 4.57, which is at page 847 of the report. This paragraph focuses specifically upon the emergency jurisdiction. But in the latter half of the paragraph, it proposes an example which would be excluded from the emergency jurisdiction of a British child in one of the Gulf states and not habitually resident in any part of the United Kingdom, and his parents were not parties to divorce, etc. proceedings in any part of the United Kingdom.
Sorry, is this about the fifth line from the bottom?
Yes. So it's probably necessary, in fact, to start slightly further up, about halfway down towards the end of the line, with a sentence that begins, thirdly, if the great majority would be sufficiently covered by the making of orders on the divorce basis. So whatever might have been the intention of the Law Commission when it embarked upon the process of formulating what became the Family Law Act, it is quite clear in our submission from the terms of the report that it knew and it advanced proposals on the basis of the scheme that it was suggesting being applicable in international situations, which, of course, one would probably never dream up a case such as this particular case when trying to formulate proposals, but certainly cases where children were abroad, where the parents were abroad, but where a divorce had taken place here, which gave rise to a ground of jurisdiction. In fact, under the Act, the primary ground of jurisdiction. So in our submission, it can't be said whether in its application, although I don't think this was the submission, but whether in its application or its intention when it was framed, that the Act wasn't intended to cover situations of this type, where there was an international conflict, as it were, between parents, but a potential forum in this jurisdiction. Moving on then, if I may, and unless there are any further questions in relation to that aspect of the case, to the more hotly contested question of what in or in connection with, for the purposes of the Act, actually means. Of course, one of the interesting aspects, or what might be one of the interesting aspects of this debate, is that on any view, where section 21B1 is engaged, there is a connection. There will always be a connection. There must be. The parents must be the same people who are engaged in the divorce proceedings. There must have been divorce proceedings in England and Wales, or matrimonial proceedings. There must be a child who is the child of the family. Each of those three things is a connection. But the framing of the debate has arguably shifted from there being a connection to sufficiency of connection. Because really the argument that's advanced, I might suggest, on behalf of the respondent here, is that whilst those connections exist, they aren't enough, and there has to be something more. And that might be thought to be a difficult submission to advance when put alongside the contention that what the court has to focus on is the ordinary words and the plain meaning of the statute. Because under the statute, this connection will exist. What the courts below, the High Court cases, have tended to focus on is that there has to be something more, and that gives rise to the opaque test, the difficulty in pinning down exactly what the court is looking for, because what that extra thing might be is very difficult, in fact, to identify. Causal link, temporal link, some consistency in terms of the facts of the divorce and the facts of the Children Act application could really be anything at all, or those things might not be enough, and that gives rise to the problem. In our submission on behalf of Reunite, that in and of itself, the fact that in connection with encompasses within its scope the connections that will automatically exist for the section to be engaged, the clarity of that as an approach and the simplicity of that as an approach weigh heavily in its favour. And on our understanding, that is in fact the test that was proposed in Le Chaux and which found favour and was held by the court to be applicable in Re T, that the two people involved were the two people involved in the divorce case or the matrimonial proceedings, that the child is a child of the family, and that one or other of those two people seeks a Section 8 order or a Section 11A order if you frame it under the terms of the Family Law Act. It is a very easy test to apply. If that test is met, then one has to adopt this Renton's phrase, the safety valve of a forum determination, whether that's under 2A4 or Section 5.2 of the Family Law Act, where the considerations might be wider. I wouldn't necessarily accept that that will involve a detailed and lengthy hearing before a court. The court may recall the aim, I don't know really whether this was ever successfully implemented, but in Spiliada the aim was that the hearing would be hours rather than days for submissions on forum. That is a laudable aim, even if it's one that's not necessarily always honoured. But in our submission, when one looks at how in or in connection with came to find its way into the statute, and when one considers that alongside the explanatory report, one finds that the simple interpretation of connection that I have just proposed and which found favour in Re T seems to be what the Law Commission, and insofar as one can tell, because of course the Law Commission produced its draft bill which was really implemented almost without amendment in the first form of the Family Law Act, also the intention of Parliament. I'm not going to rehearse all of the various parts of the Law Commission report that are covered in the judgments in both Le Chaux and Re T. The reason why we provided over lunch the two documents that we did is because they demonstrate how in or in connection with came to find its way into the Family Law Act, which might be helpful in trying to determine what it meant. So if I can refer to those two documents, I hope not at any particular great length. So looking at the draft bill, in or in connection with first comes in section 4.5. Just to set this version, and we provided the original of the Family Law Act because section 4 is in the same terms in the Act as it is in the draft. This was pre-Children Act 1989. At that point, as section 4.1 of the draft makes clear, there was a jurisdiction to make orders in relation to the custody or education of a child pursuant to section 42.1 of the Matrimonial Causes Act. If it would be helpful, I'm not suggesting the court needs to turn it up. We don't have that section separately in the bundle, but it's quoted in the judgment in Re T at paragraph 78, which is at page 958 of the authorities bundle. So it is before court.
Yes. And that's where it said, or at any time thereafter.
Yes.
Yes.
So the jurisdiction to make orders in respect, as it said in the quote there, in respect of a child under the age of 18, arose under section 42.1 during proceedings for divorce, nullity of marriage or judicial separation before or on granting a decree or at any time thereafter. So that was the jurisdiction that existed to make those orders at the time. Going back then to section 4.5 of the draft or the Act as originally implemented, whichever is most convenient, one sees the way that that section is drafted. Where a court has jurisdiction to make an order under section 42.1 of the Matrimonial Causes Act 1973 in or in connection with proceedings for divorce, nullity, etc., but considers it would be more appropriate for matters relating to the custody of the child to be determined outside England and Wales, the court may effectively stay the proceeding. But what is clear in our submission from that is that in or in connection with used in that context was not advancing any test at all. It is describing a jurisdiction that existed under Section 42.1 of the Matrimonial Causes Act. And it describes it in a particular way, because of course under Section 42.1 the court has jurisdiction in those proceedings whilst the petition is being considered, or until the time the decree is made, and it has jurisdiction after. So in or in connection with is divided into two parts. In, while the proceedings are live, in connection with, when the divorce has been determined, other than by dismissal, which is dealt with separately, but are taken to be continuing.
So what you're saying that the in connection with is after the grant of, after the conclusion of the at any time after the conclusion of the proceedings.
Yes.
Yeah.
It is simply making reference to the ongoing jurisdiction that the court had under Section 42.1. It can't be a test in the context in which it's used. It's not imposing any higher standard of connection, but that which already exists under Section 42.1. Matters are then potentially complicated by the amendments that were made both to the 1986 Act and to the Matrimonial Causes Act by the Children Act, because Section 42.1 was repealed, replaced by the power to make Section 8 orders, and Section 4 of the Family Law Act was repealed and replaced by Sections 2 and 2A in the way that we now see them. This language, in or in connection with, was imported across. So the direct link between in or in connection with and Section, I'm terribly sorry, moved behind my lady's lamp. The direct connection between in or in connection with and Section 42.1 is lost. And the question becomes, well, in moving it, transposing it from Section 4 in this way to Sections 2 and 2A, was Parliament intending to add restrictions to the jurisdiction that already existed, to impose additional hurdles that a litigant must cross to require a temporal or causal connection, whereas before one didn't need to? And there is nothing that we have done our own researches of Hansard and the parliamentary publications to see if anything was said about any of this. We couldn't find anything. I imagine from Miss Renton's comments that her team have done the same. There isn't anything to suggest, and this is a point that my Lord made in the judgment in Re T, that at any stage either the Law Commission or Parliament were intending to restrict the jurisdiction that was previously available under Section 42.1. But, for whatever reason, in or in connection with has moved from being what I would submit is a description of an existing jurisdiction, as it was initially used, to becoming a test, a standard that has to be met. And in my submission, that's wrong. The approach that was taken in Le Chaux and in Re T is consistent with the previous approach. Because...
Is there not some rule of statutory construction that if the same words are used, that they have the same meaning as the previous iteration?
My Lord has put me on the spot and I can't give you an answer, but it
I'm just thinking
is a proposition that makes sense.
Yeah,
Anyway, okay. But so you would say that those words should continue to be viewed as being descriptive,
yes,
of the factor, the connecting factors that you mentioned.
Yes, indeed. Which is consistent with an ordinary understanding of the word connection, a link between two people or things, meets the needs of children generally, we would submit, because it's clear, simple to apply, and can be dealt with on a swift basis without the need for days-long hearings to try and work out whether there is a factual link or not. Avoids outcomes that might be thought not to be in the interests of children, which of course, as we know from the Law Commission report, was a particular focus of the Law Commission in formulating the jurisdictional scheme in the way that it did, and appears to meet exactly what the Law Commission was saying it was trying to achieve within its explanatory material, which is another way of saying, but by a different route, that Reunite submits that the conclusion in Re-T was correct and should be followed now. The arguments that have been raised against it in our submission don't dislodge the sense of that conclusion, however one judges it, whether on the basis of the ordinary language or the explanatory documents or otherwise. My lady, my lords, the last point, unless there's anything further that you would ask me about that submission, is in relation to the use of the 1996 Hague Convention as an interpretive tool in this case. We have dealt with that, in fact, in relatively significant amount of detail in our skeleton argument. In our submission, the opportunity for conflict simply doesn't arise. Either the case falls under the 96 Hague Convention or it doesn't. If it doesn't, the Family Law Act can be applied subject to any decision about forum. If it does, the Family Law Act simply isn't reached. It isn't necessary to go into a great amount of examination of the terms of either instrument in order to reach that conclusion in our submission. But we have set all of that out within our skeleton argument at paragraph 13 onwards.
13.
13, 1, 3. Can I turn my back very quickly? Is there anything further that I can...
Not from us. Thank you very much indeed, Mr. Gresham. Yes, reply, Mr. Tyler. Anything?
Yeah, just the two shortest points, please. Firstly, with apologies for going back to this page we've gazed at for so long. Paragraph 35 of my skeleton.
I think it nearly opens itself now, Mr. Tyler.
I think so. But it's really with reference to the distinction between my Lord Justice Jackson's point that the rebuttable presumption is in relation to the existence of parentage, compared with James Mumby having described it as a rebuttable presumption of consent. And in fact, the more one looks at this, the more confusing the phrase looks. Arguably, there are two separate rebuttable presumptions created in that one short phrase. So, firstly, the other party to the civil partnership or marriage is to be treated as a parent of the child unless X. So that's the first presumption. But the X in question is that unless it is shown that she did not consent to the placing in W of the embryo, etc. So it puts on the person seeking to prove X the burden of proving the negative. So as a matter of law, the positive exists unless and until the negative is proven, which of course is in itself at least a rebuttable assumption, if not presumption. So perhaps that's why different people look at that and interpret it differently. But it's certainly an oddly worded...
Well, could it be said that one's legal? In other words, the other party is to be treated as a parent, which is the legal issue, and the other is evidential.
Yes.
But there's an evidential burden on the person who's seeking to establish, that they did not consent, which could be either parent of establishing that, overcoming that evidential burden.
Yes. So perhaps one is a rebuttable presumption, one is an evidential burden. But either way, there's and the fact that they're negative makes it more complicated. But I add that simply to make it less rather than more clear.
There's only one way out of the presumption of parentage. I mean, it's a room that only has one door.
Yes. And the question which my Lord raised earlier is the way in which to find that door. And the second and final point, please, may I just give you 6-page references to look at or not as you see fit afterwards, all from the supplemental bundle. And these are the numbers which will appear in black at the bottom of Lord Justice Jackson's document rather than anyone else.
Can you describe them?
Oh yes, it's
When you know that it's an Exhibit 11 or whatever it might be.
well, they're all in Exhibit 1
Okay.
to a statement. So they're pages 460, 461, 464, 465, 473 and 506. And 4 of them are examples.
473
and 506.
Thank you.
And 4 of them are examples from the clinic notes where my client is referred to, although never properly as a partner. In fact, once the fact of there being a same-sex partner is listed under the allergies section rather than anything else. But perhaps that's explained because one of the 2 other documents makes it clear what the state of the law was at the time, because it's a consent for intrauterine insemination form, which has 1 line for signature of parents.
Sorry, what page are you looking at
This is
now?
page 465, my lord.
Thank you.
Which exhibit is it?
First. Exhibit 1, I think.
It's Exhibit 1 to whichever statement.
To which statement?
To the applicant's statement in response to the respondent's statement on parenting.
It's the second group of children.
Okay. So Exhibit 1.
Yeah.
What
And
page
this is the 21st page of the exhibit, which is page 465 of some of our printed.
Yeah, something like that for us.
So what page of the exhibit?
I think it's the 21st page.
What's it headed?
There's a black circle with a split down it, which I imagine is an early embryo. And then the
Anonymous
name
donors,
of the
donor
clinic
match
company.
confirmation.
And it's called Consent for Use of Anonymous Donor Sperm.
Got it. 488.
22nd of August 2010.
Thank you.
Yes.
And the NA is for husband or partner on that page.
Yes. And then on the page after that,
Male partner.
a male partner. So it's just if the court is interested in more in the point that was taken against us in relation to the appellant's involvement or not, we don't take issue with the notion that a same-sex couple would be treated, and no doubt the non-mother would be well looked after, well treated, kindly treated. But we see from this form that in terms of consent, this is to our point about the law, there's a patient that's involved and there's a possible male partner that's involved, but that is it. Maybe, are there any other matters with which we can assist?
Else?
No, well, thank you very much.
No, thank you very much indeed, Mr. Tanner. Well, thank you all very much indeed for, effectively, as my Lord said, 2 appeals. We're very conscious that it's a very important case, not just from a legal point of view, but of the utmost importance to both parties in this case, who I think I've observed in court, both of you, and no doubt it's been a very difficult day for them. We will, of course, reserve our judgments. I can't tell you precisely when we'll deliver out our draft judgments, but it will be as soon as we reasonably can. Normal rules apply, please. Draft for typographical errors, minor corrections, not to re-argue the case. I'm sure by now everyone's got used to the new embargo on the top of the draft, but may I just remind you about it and ask you to ensure that we get our lists and that you make sure that anyone that does have sight of our draft knows exactly what the embargo means and just how seriously this court take it. So can I thank again all of you who have appeared pro bono and everyone behind you who has worked very hard in order to prepare this matter in an exemplary manner, and really we don't care about the numbering when we get such expert representation for people free. Can I just mention you, Miss Renton, in my BAFTAs, and just say to you, to thank you for the daunting task of dealing with REIT in front of its author. We're very grateful to all of you. Very well. Unless there's anything else we need to deal with, anything else we could deal with in writing. Thank you very much.